afternoon, everyone, and welcome to Fridays with Keenan's Cutting Edge, where we discuss all things edge. My name is Jenna, and I will be your host as we explore the dynamic world of Don Keenan's trial philosophy, The Cutting Edge. Those of you joining us live this afternoon are receiving early bird access to this episode. You have the opportunity to ask questions and interact with our speaker. If you have a question, please type it into the comments section below, and we will be sure to address it. If you happen to be unable to join us live, episodes will be released each week following the live broadcast. So be sure to hit that subscribe button and click the alerts icon to make sure you don't miss an episode. Today, we have the Keenan Trial Institute Dean of all Deans, David Hoey, with us, speaking on the new premises revolution. Now, the cutting edge truly is a dynamic trial philosophy. At its core, the cutting edge is about meeting jurors where they are and delivering our client's message in a way they can identify with. If you know anything about people, you know we are an ever-changing and fickle group of mammals. What works today to convince me of your case might not work tomorrow. Papa Don makes it his business to have his finger on the pulse of the people, and he regularly updates his methods to make sure we are all able to continue meeting their needs. David Hoey is a big part of updating those methods as Papa Don's right-hand man and currently heads up the premises section of Keenan Law Firm's referring attorney program. David practices law in Boston, Massachusetts. We'll put a link to his website as well as his contact information in the description below so that you can reach out to him directly with any questions after this episode. All right, David, tell us what is new and exciting in the world of the Edge Premises section.
Thank you, Jenna. Good to see you from state of Washington all the way over here in New England. What I wanted to do today for the next 45 minutes to an hour is invite anybody who has questions during the presentation to go ahead and ask them. It's easier to address them as I move along than it is at the very end and run out of time. But I also wanted to show everybody how premises cases are actually very simple, easy cases to prepare. And where does it start? Well, it starts with certain fundamentals of law. So let me start like this. Every 4 minutes and 45 seconds, someone is a victim of a violent crime inside a commercial parking lot or garage. This is according to the United States Department of Justice statistics for crime for the years 2004 through 2008. As a result of that, commercial parking garage owners and managers must take all reasonable steps to prevent crime on their premises. In addition, commercial parking garage owners and managers, after a violent crime has occurred, must install cameras to deter a repeat crime in the same area. And also, commercial parking garage owners and managers, after a violent crime has occurred, must concentrate the security force in the area of the crime. Now, why did I lay that out like that? Well, premises cases are going to fall into one of these three categories: failure to warn of an existing danger, the failure to guard against a known danger, and the failure to repair and make safe when necessary. Now, there are some traps for the wary or unwary that hopefully I'll hit upon when it comes to certain kinds of premises cases. But normally, a premises case is going to fall into one of those three categories: failure to warn of an existing danger, failure to guard of a known danger, and failure to repair and make safe the property or premises. Now, the duty of these things may differ from between a landlord, a commercial property owner like a mall, or parking garage or hotel, hospital, school, which is a hot topic these days because of the shooting cases. Hopefully I'll be able to address a little bit about that. Playgrounds, also considered a premises case. Municipalities, governmental properties and buildings. I mean, look at the I'll call it a riot down on our national capital. That's a premises case. The reasonable standard, the reason I started off this presentation with a very strong statistic from the Department of Justice, keeps track of the crimes in our country, which is fed by all the different police departments in our country and sheriffs, is this reasonable standard in premises cases. You know, unlike some products cases, which I also do a lot of, which is you have some strict liability in those cases. Premises cases can be similar to a strict liability case, but it's this reasonable standard. The problem with a reasonable standard is if you poll 12 jurors, or if you do this in a focus group or a real jury, you poll 12 of those jurors, you may get 12 different determinations as to what is reasonable under the circumstances. And some are going to believe that the reasonable standard is this extreme safety standard, and others are going to believe, no, it's something very less, and you have a whole bunch in the middle, and it gets very confusing. And I've even seen juries come back and ask a judge, what is reasonable? And the judge says, I can't tell you what was reasonable. That's something for you to determine based upon what was presented through expert testimony, blah, 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 blah. So the reason I gave you the opening that I did wasn't as part, it was what commercial parking garage owners had to do, what we consider to be reasonable, which would have been supported by industry standards, which was supported by expert testimony, which was supported by a director of security, which was supported by police officers who testified in the case. Those measures deter crime by installing a camera, concentrate your security force in the areas of where the crime on the property has occurred already, and knowing what the crime data in the area or in the nation is, so that you can prepare for it. When it's presented in that format, reasonability becomes very clear. Well, yeah, that sounds reasonable to put cameras up, and the cameras will deter people from doing bad things. Yeah, that sounds reasonable to concentrate the security where the crimes have been occurring. And yeah, that sounds reasonable. Those are governmental statistics by the U.S. Department of Justice. They should know that. That's something they should know. It boils down to be as simple as that. What happens is plaintiff's lawyers complicate the you-know-what out of it and don't provide the jury with what is reasonable, leaving the jury to guess. And whenever you leave a jury to guess, they are going to fill in the blanks with their own determination because we didn't provide it to them. And this is the other issue becomes, if you're going to present what is reasonable, you have to also present that it's feasible. Feasibility. And in terms of it's feasible, let's say this had 4 floors of parking garages. Well, that would be 4 to 8 cameras. You can have them pointed at all the elevators, or you can have them pointed at the floor. You know, the cost of doing something like that is not astronomical. It's feasible under the circumstances. And when you calculate it with the number of parking spots in there and how much they charge per parking spot, it becomes very, very feasible to install safety measures in there. Now, what may not become feasible, but the risks versus the reward is personnel, right? Say security that needs to roam the premises, that needs to get trained, that needs to be supervised. You need coverage when they call in sick or on vacation or what have you. Yes, personnel becomes expensive. But if you do it right, it's going to save the premises a lot of money. And reputation is a big to-do. Malls, parking garages, school areas, certain restaurant areas in town, hotels, big time hotels. And their reputation is whether it's safe to go to or not. And then you get into what the patrons of premises should know. That becomes the warning issue. If crime
I've got a question, if you don't mind, from the audience, and I think it works here pretty well with what you're talking about. So we have this from observer or viewer DBT, and I apologize, I don't have the full name, but this person asks, does it matter if the injury was from a slip and fall versus a crime or like a robbery or shooting victim? What do you think?
Well, yeah, of course it does. It depends. So if the reason for the slip and fall is because they're running away from being mugged, yeah, of course. But if it's a slip and fall, and I'm going to talk about slip and falls, hopefully we have enough time to talk about slip and falls, because there's all types of slip and falls, particularly up here in New England, and we're getting ready for the snow and ice season. There's a slip and fall every day, and there's some duties and obligations. But if you're talking about a parking garage or a hotel slip and fall, it's not so much of a security measure, but it can be very much a notice of knowledge measure. And I have an example coming up momentarily about a code violation, a safety code violation that caused a sort of a slip and fall. But most slip and fall premises cases, what you're looking for is a notice of knowledge issue or a, what's the word I just used? Notice of knowledge or a code, a safety code violation, all right? That's where you want to go with your slip and fall cases. You know, we learned at the old, slip and fall on the banana peel that's been left on the grocery floor for an extended period of time. Well, it was there for longer than an hour. Well, then it's reasonable to believe that the store owner should have cleaned it up. But it was only there for 2 minutes. Then that's not reasonable enough for the store owner to pick it up. Not everybody can be Mo Levine, where Mo Levine would make the presentation, don't look on my floors. I'll keep the floors safe and clean for you. Look at the merchandise on my shelves. Those are the things you need to buy. It's nowadays on the slip and fall cases, I'm looking for a safety code violation, or something was in existence for a long period of time. Thereby, the property owner didn't warn of its hazard, didn't repair or fix the hazard, or didn't guard against the hazard, putting up a cone, roping it off, or what have you. So again, slip and fall, any premises case has got to go back to one of those three types. If it was a known danger, did they warn? Did they repair or fix it? Did they guard against it? If they didn't do all three, then there's an issue. There's a problem. I'll talk a little bit about my good friend Greg Luther's favorite topic, foreseeability, because all these, what is reasonable, boils down to whether it was foreseeable or not. And of course, that's one area that the judges struggle with, I should say, is foreseeability. No, let's face it, this isn't a crack on judges. Most judges do not practice in the personal injury arena. And so having to do a foreseeability analysis to them is like Chinese.
We don't even have foreseeability in our jury instructions in Washington in our negligence cases. So it's a foreign concept in some jurisdictions.
But do you have notice and knowledge?
Sometimes.
Yeah.
But that's what we always put any evidence that we want to talk about in that area. It showed notice. They knew about it. They should have done something.
That's foreseeability, right?
Absolutely.
Zone of danger you might have, okay? Whether somebody falls within that zone of danger, you may have that in states that don't use the true word. Predictability. If something is predictable, it can be preventable. I mean, isn't that what foreseeability really is? Yeah.
Absolutely. It's the ability to be able to do something about it and prevent the bad outcome.
Yeah. Yeah. Or guard against it, repair it, or warn against it. Right. So it's a reasonable standard. This is one of the better standards. I took the Massachusetts definition, and anyone who owns property must maintain their property in a reasonable and safe condition for lawful visitors. But then we just answered it. The question remains, what is reasonable under the circumstances? And the example I gave you is something that's reasonable and feasible. And here we go to the foreseeability issue. We just discussed that at a good clip. Whether it was predictable is whether it's preventable. Notice equals knowledge, and you can do an awful lot with knowledge. You know, some of this is the foundations of law, but the foundations of law that have existed since the 1800s and early 1900s still applies today, and we need to apply it to our cases. Plain and simple. That's how we win the majority of our cases. Now, one of the things I wanted to say is that the premises cases are starting to change, and they're starting to overlap with other types of cases. So a lot of the premises cases are because I do a lot of products stuff, and I've done a lot of premises cases. The premises cases have an overlap with products cases. I'll give you some examples. So we're working on a case that is a school, grammar school, middle school age kids. And the school purchased a playground. I think it's called rope and climb or something like that. It's not a traditional playground with swings and a sandbox, but it's more of an advanced type playground where the kids can climb rocks, climb ropes, have ladders between the two and all that kind of thing. And what we're finding out is that the school relied on the manufacturer and distributor of this ropes and play, that it's safe, that it's been, tested, that it's able to be used. But one of the things they didn't say is that it's actually inherently dangerous for young kids if they're not supervised. And the number of supervision that it needs for the number of kids using the playground. So the school bought it and the kids used it, and sure enough, a child broke her back using it, and there wasn't enough supervision. So there's a cross case. You got negligent supervision against the school and municipality, which is probably capped. And then you have a negligent design and a negligent warning and instructions and warning against the rocks and play. There's plenty of examples like that, but you would need both in your case to compensate the plaintiff for the extent of her injuries. If you're 9 years old and you break your back, that's usually a lifelong injury of some sort. Daycare centers, holy cow. other than the COVID year where everybody had to stay home, a year and a half, everybody had to stay home, daycare centers are loaded with premises problems. In this particular case that we're working on, you have a daycare center that bought a bunch of these rockers, young baby rockers. They're called sleeper rockers, where the child can be rocking in the chair or the child can fall asleep in the chair. What the day center didn't know was that these are also inherently dangerous because children can suffocate in them and have breathing problems when they're not old enough to keep their heads up, and also stop breathing and die. And that's exactly what happened. So we have the day center, because it happened on their watch, and we have the sleeper manufacturer and distributor for a defective product. Shipyards and the heavy cranes. The shipyards use these heavy cranes to build boats, and we're working on a case. And what we've realized is that the heavy cranes, you see a picture of one that collapsed over there. There's a couple things wrong with them. One is there is OSIs, other similar incidents, many of them, all over the world, where these cranes collapsed. And why do they collapse? Because two things: poor instructions, poor warnings, and poor weight distribution. So they have a way to attach weights on the back end of the cranes where the weights don't fall off. Well, what happens is if the crane lifts too much, and there's not enough weight holding the back end, the crane's going to tip, and then the weights fall off, and then the crane falls. But the other part is on the shipyards, everything's got to be flat. If there's any incline, that affects the movement of the crane as well. So you have a premises case roped in with a products case. But we wouldn't know that unless you're doing your homework on these kind of cases and thinking of outside the box. It's just not a premises case, or it's just not a products case. Amusement parks are a hot topic. Almost every week you pick up the paper, you're reading about an amusement park problem. Okay. Amusement parks' big issue is they don't want the ride to shut down. When they shut the ride down, people don't come to the park. They lose revenue. Hundreds, if not thousands of people, especially when the parks are open at night, ride a roller coaster. Because a roller coaster is really only a 3-minute ride. It might feel a lot longer, but it's only a 3-minute ride. And think of how many people they can circulate through on a 3-minute, excuse me, a 3-minute ride. Well, over here, you'll see a roller coaster car that derailed. It derailed because it had defective parts. So again, you have a premises case coupled with the products case. Now this one's kind of interesting, and here's where I want to talk a little bit about a code violation. So back in the day when I used to do a lot of assisted living cases, nursing home cases, elder abuse and neglect cases, I used to get a lot of these threshold, what we call threshold cases. You can see my mouse down here. That's a small rubber threshold that's the same color as the carpet. And the code says that it can only be, I think, a 1/4 of an inch in height, so that wheelchairs and walkers and people with heels can get over it without something happening. So I hope this plays for you. And you can see what happened.
This video shows how little effort it takes for the stroller to fall forward.
All right, so you should get the idea. As the woman was pushing her walker with 4 wheels, she hit that front threshold and toppled over. Cracked her head and died. So we went after the assisted living facility for having a threshold that was too high against safety code. And we went after the product manufacturer for the walkers that tip over. Now, there's plenty of those walker cases out there, but and there's a small, cheap device that you can put on there so that the walker doesn't tip. A little plastic triangle piece you can put on one of the front tires so it doesn't tip over if it hits a curbing or a threshold like that. I thought I had the picture of the threshold, but yeah, so that was both premises as well as a product case. Now, recently in the news, it seems like it's all the time. You see all the school shooting cases, the church shooting cases, the mall shooting cases, the public events like out in the Vegas, the shooting cases and the gun cases. Now, you have a bunch of the advocates out there that say those are gun cases, you know, and then you have, but are they, you know, and are they more of a premises case? Well, these are difficult cases to deal with because of the foreseeability part. If you look at Sandy Hook in Connecticut, small little Connecticut community, there was no expectation that somebody would walk into their little school that's been around since the early 1900s and start a shooting spree. But it happened. And if you go back and you look into that case, Remington, which is a gun manufacturer, sort of did the right thing and contributed a large sum of money to the victims' families. They weren't saying that it was a gun manufacturing product problem. They were just in support that a tragedy like this is not something that just doesn't happen. You have innocent children that were affected by that. And I think the gun manufacturers were trying to get some good publicity out of doing something kind like that. I think it's the right thing for them to do. There were other theories of liability that went around on the school cases, the church cases, the mall cases, and the public event cases. Some stuck, some did not stick. But as a result of these, schools, churches, malls, public places are now aware. Certain areas of the country, they can predict it. You'll probably notice that many schools have a roaming police officer now. You have to buzz to get yourself into the building. You can't no longer just freely walk in. There's cameras at the front doors now. The parking lots are now monitored. Some schools even have gone as far as having metal detectors at the doors. So these tragedies, as sad as they are, the level of safety precautions that have gone into place, things like this shouldn't be happening again. And let's hope that stays that way. Now, there is a couple that I can talk to you about For instance, anybody who's into music, anybody who's from the New England area, maybe even New York, a little bit will remember the Great White tragedy down in Rhode Island, near Providence, Rhode Island, 2003. And this was, 109 or 110 people that packed into a small club, bar type club, to listen to a heavy metal type rock band play. And their equipment caught on fire, and there wasn't fire protection, and about 109 or 110 people died and perished. There was trampling, there was a panic, and it was a mess. The bar / venue had very limited amount of liability insurance, and the property was worth nothing, especially after it burned down. So the lawyers, to compensate these victims, had to look at other angles and other ways in which to get fair, just compensation for the victims. Now, I gave you a list here of all the contributors that contributed to that tragedy, and each one of them had a level of liability assessed against them. So when you wanted to boil down, how can this happen? Well, you started off with, there was no fire inspection. Then you started off with, they overcrowded beyond capacity the bar or venue. Then you went into all the things that contributed to the fire, the air conditioning, and the other products in the building, because this thing went up in flames in a hurry. Then you went into the level of staff and security and why people were being trampled on and pushed and shoved, and they couldn't get out. It was bottlenecked. But here was the catch. Anheuser-Busch was the sponsor of the event. And Anheuser-Busch didn't do anything to check on the venue. They just put their banners up, sold their Bud Light, paid some money to have the band play, but did nothing other than that. And that was the hook to get Anheuser-Busch to contribute a lot of compensation to these poor people that just didn't deserve, out for a good time. They have the expectation that something like this isn't going to go wrong, and if something like this goes wrong, they're going to get out of it safely, and they didn't. Maybe they relied on the fact that Anheuser-Busch was sponsoring the event. Maybe they didn't. But either way, Anheuser-Busch, as a sponsor to this event, had liability. And again, my point is, you got to think outside the box and look at the radio station that shared in liability because they promoted this. Again, they were selling the tickets. They were promoting it, but they did nothing to determine whether the venue was a safe venue. And that led to a level of liability, to a level of compensation. I don't know if it was fair and just, but it was something for that many victims. Remember the Aaron Andrews case in 2008, the peephole incident against Marriott? Okay, that's a premises case. And let me tell you this, after doing a few hotel cases, that stuff happens all the time. We only heard about the Aaron Andrews case because she's, in the limelight, but it happens all the time. All sorts of security breaches, it happens. There's all sorts of ways that people fool the front desk to get into the hotel and get access to certain rooms, whether it's for robbery, whether it's to pursue somebody. It's bad. And you need to be aware of it. It exists. Identity theft is big. That's big in nursing homes and assisted living as well. The aides steal the residents' identification, and they go out and they get credit cards. And I've even had an aide buy a home using an elderly person's information. So the hotel industry is well aware of these problems, and oftentimes let their guard down. Yeah, they have video cameras now all over the place. But here's the issue with video cameras in premises cases. They're designed to deter, and they do, but not all the time. Good security using cameras, there's somebody watching the cameras at all times, and then can intercept when there's an issue. But again, that costs money. And then you have to pay somebody to sit there and watch 15 different monitors. But it can be done. It has been done, and it's a good way for prevention. And there's cameras now hidden in places you never even knew they're hidden. Check the plants out next time you go into a hotel. Look around in the plants. They look like it's a water spout, but it's really a camera. So, if you go back to the 2015 Charleston Church massacre case, there, the family sued the FBI because the FBI had enough information through their background checks and surveillances and information that was provided to them of information that may have been able to prevent the church massacre. In 2017, you had the Nevada Harvest Country Music Festival shooting. The lawsuit was filed on behalf of the 450 victims against the hotel because they allowed this guy to bring in all sorts of weapons, set up camp in there, and fire at will. And there was some signs and signals that would have given them, a red flag. That's the other thing you're always looking for in premises cases, red flags. How many red flags are there leading up to the event that you can point to? One red flag, tricky. But when you got 4 or 5 red flags and nobody's eyebrows went up, you're gonna have a problem there. There was for the 450 victims, 800 million was raised by the hotel chain MGM Resorts, and I think the gun manufacturers also contributed some money. Again, not admitting to any liability, but as what I believe to be a public policy event. In 2016, the Pulse nightclub shooting, which I think that was down in Miami area or Florida area. Same thing as that nightclub in the Providence area. Twitter was sued, Facebook was sued, Google was sued. All the promoters and sponsors of the nightclub were sued. So, my whole point is you got to think about what is reasonable under the circumstances and thinking outside the box when we have these tragedies like this. There was an old saying from one of the first law firms that I worked for was if you have the damages, you'll find the liability. Well, part of that is true. And don't be afraid when you find that the number one defendant in the case may only have limited insurance. There's always something behind that you need to explore and get to. I call them the Kmart cases. This is what put Kmart out of business. For years, Kmart used to sell guns to minors and people who are not qualified to purchase a gun. And then that gun would be used in crimes, were all over the place. And they would trace back to where the gun was purchased and who bought the gun. And a big case, I think it was out of Utah. Yeah. Put Kmart into bankruptcy. They filed bankruptcy the day after the verdict. But there was a whole slew of those cases. I didn't think those type of cases existed anymore, but they do. They do. Another area that's back at it. So let's talk about these crimes. A lot of these premises cases have to do with crimes, crime statistics, crime data, and it's a necessity if you're going to do any type of premises case that has crimes in it. So the crime data is the key. The trends and the cycles is what you're looking for. And this is stuff you can do on your own. Don't think you can gather all this stuff from the local police department and have to send it out to have review. No, this is something you can sit down, draw out a chart, and start making the lists. And here's the thing, here's a mistake I've often seen, that the attorneys who gather all the crime data are only looking for the violent crimes. No, you want all crimes. And the reason you want all crimes is because the petty crimes, the misdemeanors, the light crimes escalate into the violent crimes. It just doesn't start with violent crimes. It starts with the small stuff and moves its way up to the big stuff. And so all the crime for the site in which the crime occurred, the premises that you're about to bring a claim against, as well as the surrounding area, and expand it as much as you can. So for instance, the city of Boston is broken up into zones. This was zone A1, where we had a case in Boston, it was zone A1. So we got all the crime stats for zone A1 and found that it was a high crime area. Well, then we said, well, you know what? Let's compare it to A2 and zone B1, which were like adjacent crime zones. Oh, lo and behold, low crime areas. So we knew we had the hot spot, and the premises was sitting within the hot spot, and it had its own crime, which I think I can show you in a second. And this is the trend you're trying to show, that there's decreased security at this particular place, but there was an increase in crime. I think I have that coming up. In terms of experts, because you're going to need an expert to talk about industry standards, feasibility, predictability, statistical data, tell the jury about the crime trend. Use a criminologist versus a retired police officer or a security expert every time. A criminologist can testify and have opinions on a vast more areas than a retired police officer or a securities expert. Criminologist is by degree. Criminologists are hired by big corporations and government and the U.S. Department of Justice and airports to give their opinions on crime prevention and crime trends and why crimes occur. So there's one lesson you take away from today. When you have a premises case that's crime-based, you're going to find yourself a criminologist versus a security expert. Now, you can have both, and they can work well together, for sure. But I'm telling you right now from experience, criminologist is the way to go. They're degreed, they've published in the business, they can analyze the data, and they can give you predictions. It was inevitable crime was going to occur, continue to occur on this property. Why is that, sir? Well, A, B, C, D, E. What's the basis of that opinion, sir? No, my education, training, skill, and knowledge. I'm a criminologist by degree. That's it. Simple. Oh, you gotta love New England, right, folks? The old slip and falls. Well, let's talk about that for a second. It used to be my favorite kind of case, and here's why. Because once you change the format of the snow or the ice, you own it. If you just leave it as a natural accumulation of snow and ice and someone slipped and fell, you don't own it. But as soon as you go out there and you start to shovel it, and you start to change the form of it, and you start to move it, and then it freezes, and somebody takes a header like this, you're going to be responsible. Now, that's a catch-22, because if you're a storefront owner and there's a municipal sidewalk out in front, as the storefront owner, you are responsible for the removal of the snow and ice out in front of your storefront, even though it's municipal property. And if you don't, you're going to get fined. But if you do, and you don't do it correctly, you're going to get sued if there's a slip and fall. So there's another rule in the snow and ice states. Within at least 1 hour after a snowstorm or ice storm, the property owner must apply salt and sand to the area. And if the landowner did apply the salt and sand, and they can document it, that they did so, and there's a slip and fall, they're going to be okay. There's also the trap for the unwary, the open and obvious danger defense. Okay, now this applies in many, many states. The open and obvious danger defense. There's no duty to warn when the open and obvious danger exists. However, that doesn't alleviate the duty to fix and repair if fixing and repair is feasible under the circumstances. So be careful of getting caught in that open and obvious danger trap, because the back to that is, hey, okay, it was open and obvious. However, because it was open and obvious, and because it existed open and obvious for such an extended period of time, you had a duty to fix and repair it, and you didn't. So that's one of the ways to get around that. Now, I see I only got 9 minutes left, and technically I'd have a lot more to go on the premises cases, but let me give you a little bit more in the last couple minutes here.
Hey, David, can I ask you a quick question we have from the audience?
Yep.
All right, so we've got, again, from DBT, thinking outside the box. Hospital patient gets a pressure ulcer because they're not moved often enough. Compare that with the guy who slipped on the banana peel that wasn't cleaned up by the store. So what makes one a premises liability case and not the other?
Night and day. So the pressure ulcer case, i.e. unrelieved pressure, shift after shift, hour after hour, day after day, with no comorbidities that can contribute to a pressure ulcer, rotting hole in somebody's skin, is as a result of staff not turning or repositioning at least every hour, not following policies and procedures, not following Nurse Practice Act, not communicating, staging, or preventing the pressure ulcer from beginning, not following the code of federal regulations, not following the code of state regulations for the prevention of pressure ulcers. That's neglect, okay? The slipping on the banana peel is truly more of a premise issue. How long was it there? Duty to guard against it, duty to warn about it, duty to repair or fix it. So they're not in it. Just because the pressure ulcer occurred in the hospital doesn't automatically make it a premises case. That's a pure neglect case by definition. Yeah, they have a duty to guard against pressure ulcers from developing. Yeah, they have a duty to not let a pressure ulcer get worse when it's a stage 1 or a stage 2, not letting it get to a stage 3 or a stage 4. And they have a duty to inform, consent, inform, i.e. warn the patient, the patient's family about the development of a pressure ulcer. So night and day, but only because I only got a couple minutes left, let me go real quick. Swimming pool cases, roller rink, ice rink cases, airport cases. The airport cases are, they know there's long delays, cancellations, and for Christ's sake, you just don't have enough defibrillators in the building. You got people, how many times have you been in an airport? You know, all of a sudden you've seen that emergency cart go by, right? Because somebody had a heart attack or a stroke for sitting so darn long. Also, real quickly, I had a roller skate rink case where they allowed underage drinking on the premises, knew about it. And the DJ who played the music in the roller rink, as the teenage kids would go around the rink in their roller skates, would allow the whip around. So they'd all, like a centipede, hold on to each other, and they'd go around and they'd whip around. Well, this one kid who fell got his fingers amputated, bing, 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 from roll over the roller skates, and he was a basketball player. There goes that life. It's, again, in the swimming pool cases, they're very interesting as well, but those are mostly supervision and lifeguard type cases. If you've ever been a trained lifeguard, you know that they're supposed to be, it's 3 second ones, 1,002, 1,003, and they're looking, A, B, C, D, all the way across the pool. But the residential pool cases are the negligent supervision, are watching young kids, are letting crazy things happen, pool parties and what have you. So I could talk to you all day long about different ideas and theories and on premises, but I'm out of time, Jenna.
Okay, well, we've got about 4 minutes left, and you can either wrap that up, or I have a couple questions that came to me
Fire up.
as you are going. All right. So I know, and I used to be one of these lawyers who was afraid to take premises cases because liability is always contested, and the public view of kind of your traditional slip and fall or your ambulance chaser lawyer tends to revolve around premises liability cases. So what would you say to lawyers who have those same concerns?
That you can't have it as just a slip and fall case. You have to determine why did the slip and fall occur. So if the slip and fall occurred because the premises, excuse me, because there's a threshold or a step down, and the landlord or the restaurant owner knew that it was a problem and didn't spray paint it orange, or didn't put up a warning sign, or didn't tell the patrons, watch your step. You always have to go one step deeper and say, why did this property owner not remove the snow and ice? Why did this property owner not warn about the step down in the restaurant? Why? And it's the answering of that why that gets you to the real case. And then you're taking the jury's focus off the fact that the person slipped and fell and onto the landowner's conduct of why they're doing it. So you need to shift. You need to think outside the box.
All right.
I don't mean to yell at you. I'm just.
No. Well, what about the shoes, David? What about the shoes that your client was wearing? I mean, come on.
Come on. They have a right to choose and wear whatever they wish to choose and wear, because they have the expectation that if they wear those shoes, because those shoes are sold probably on the internet now versus a shoe store, that rugs are going to be tacked down in lobbies. Steps are going to be orange or yellow and marked. They're going to be okay.
Mm-hmm. Okay. All right. And then I have one final question. Let's use this last minute for that. How do you deal with the intentional tort aspect of a criminal premises case, right? With that intentional actor and then the whoever the corporation or hotel is saying, hey, it's all that guy.
That's an easy one. I only have 1 minute, which is great. You go and ask them.
Who do you mean by going in and asking who?
They're criminal.
Interesting. Okay. And what are you trying to elicit from that criminal?
Why he or she did what they did, and why they picked that property to do what they did.
All right.
And if you got pizza and orange juice, bring it. And if the warden will let you bring it, good for you. If not, blame the warden. You'll get more out of it.
All right. Awesome. Well, thank you so much, David. And thank you to all of you who joined us for this week's episode of Fridays with Keenan's Cutting Edge. If you liked today's video, please click that thumbs up and don't forget to subscribe and sign up for alerts so you don't miss an episode. This podcast is about delivering what you want to hear. So don't be shy about sharing topic ideas with us in the comments section. As Papa Don always says, if you want to know more about it, chances are someone else does too. Next week, we will be hearing from Doug Dykes and Clayton Seifert. And I apologize, Clayton, I don't know how to pronounce your last name. Hopefully that was close. But we'll be hearing from Doug and Clayton as part of our Superstar series. They achieved a stellar result in a recent case and will be sharing how the EDGE method helped them get justice for their client. I can't wait to hear what worked for them and to get some inspiration for my own cases along with all of you. Have a wonderful weekend, and I'll see you next time.